So all you ever hear about is Chapter 7 bankruptcy. But why not 13? Check out our next video and find out why you shouldn't be afraid of Chapter 13. In fact, a lot of times it's a much better choice. So this video, I want to talk about Chapter 13 and why you shouldn't be afraid of Chapter 13. So let me kind of explain really quick the differences between Chapter 7 and Chapter 13. Well, a Chapter 7 is typically what most people think about when they hear bankruptcy, or they'll call it a straight bankruptcy. In a Chapter 7 case, you're not restructuring and repaying your debts. You're just getting rid of those debts which you're eligible to get rid of. But there's no repayment plan. You're usually out in about 4 or 5 months. And yes, they typically cost less than a Chapter 13 because you're not really in the case very long, whereas in a Chapter 13 case, you're going to be in a debt consolidation repayment plan. And these cases will last anywhere usually from 36 months to 60 months. So of course, there's more legal work involved, so they are going to cost more than a Chapter 7. But let's talk about a couple of things that you really need to think about when you're considering bankruptcy, and you want to make sure that you go over these questions with your attorney. Because sometimes attorneys actually don't even do Chapter 13s and they'll try to push everybody into Chapter 7s, and this can be a problem. Let me tell you why. So Chapter 7 and Chapter 13 actually have different code sections, so there are different laws that apply to each chapter. One of the biggest differences I can tell you is in a Chapter 7 bankruptcy, you don't have an absolute right to dismiss your case if you don't like what the trustee is proposing to do with your property. Now, you have that right in a Chapter 13 bankruptcy. And I will tell you this at the beginning of the video. Chapter 13 is always going to give you more control over your money and over your assets. And if at any time you don't like how a court ruling comes out or how a trustee is judging your case, you can just dismiss your case. So that is a huge advantage that it's going to have over a Chapter 7. But let's talk about Chapter 7. You don't have an absolute right to dismiss your case. Now, there are some circumstances, especially when you really don't have any assets, where the court's not going to have a problem with you dismissing your case. In fact, we do Chapter 7 dismissals probably a few times a year for reasons like this. I will have a client that they file Chapter 7, and one of my clients literally had a massive heart attack, no health insurance coverage, 3 weeks after he filed. Well, what we did is we just dismissed his Chapter 7 case. We had to file a motion. We actually had to have a hearing on the matter, but the court allowed it, and then he was able to refile once all of his medical bills, he knew what they were, and we could put them in the new case. So things like that, yes, you can dismiss a case in Chapter 7, but it is not a guaranteed dismissal. Now, a Chapter 13 case is different. In a Chapter 13 case, you can be at any time during your case, going right along, and for whatever reason, if you decide that you don't want to be in bankruptcy anymore, you feel like it's just too much of a struggle, or you've decided you're going to give up assets, if you want to dismiss the case, you can dismiss it. So we just file a motion and you will be granted that dismissal. So that's great. There's no court hearing where the judge and the trustee are going to look at everything and maybe another party is going to argue you shouldn't be able to dismiss your case. So that's not going to happen in Chapter 13. And you're probably wondering, okay, yeah, but I know I'm going to file a 7 because I just have too much debt. And that may be the case. If you are one of those people that you don't really have anything in assets, you just have a bunch of debt, 7 is great, probably your best choice. But you need to really, again, make sure that you know what your assets really are and that you go over these concerns with your attorney, because let me talk about a couple of situations where this is going to come up. So the first thing is going to be equity in assets. Now, some folks don't think about what is an asset. They think of an asset like your home, your car, but you can have other assets. So for instance, if you are in a lawsuit and you have a claim against another party, that's an asset. If you are on the property title of your mom and dad's house with your brothers and sisters, and a lot of people do this, that's an asset. And you might not think of it as your asset, but that's an asset. And your equity in that asset is actually an asset of the estate. So that could be a problem when you file bankruptcy if you don't have enough of an exemption to protect that. So you need to think about that as well. A couple of other things people don't consider is, I can tell you personally, here in the Northern District of Georgia, seen some very interesting cases come up lately. Actually, two of them were my cases, and one of those involved one of my clients who she had gotten divorced many years ago. I want to say it was probably like 9 years ago. And per the divorce settlement, she had been a housewife and supported her husband with his career. She received a portion of his retirement. And so in her case, she was smart. She had great counsel. And as soon as she received those funds, she put those funds into her own retirement account. So even though she received them from her ex-husband, she transferred them into her account. Well, when she filed a Chapter 7 case, the trustee actually kept her case open for a while, and we thought we may have to go to court over it, because the trustee was trying to argue that her retirement account shouldn't be given the protection afforded normal retirement accounts, because the money that she had put in it had come from her divorce. Now, in our case, we were able to successfully argue with the trustee about it. It didn't have to go to trial, and it was resolved. My client didn't have to pay a dime. She kept everything. But these are some very important things you need to be aware of. If you have an inherited IRA, meaning, you have a relative that passes away and they leave you an IRA, 401k, that's not protected as if it was your own. And so you need to make sure, if you have assets like that, you're able to cover those with your wild card exemption, because if you file bankruptcy, trustee is going to take that money. Another thing you need to be aware of is sometimes financial advisors have structured retirement accounts that some of the retirement account actually is not in we call it a protected account in regards to tax treatment. And so it's just as if you have an open, bank account or savings account out there. So before you file bankruptcy, you want to make sure you're going over your retirement accounts to make sure that they are actually protected. Because I saw a case not too long ago, and the financial advisor gave the client bad advice and told them, oh no, this is a protected account. And so they listed their account as an IRA, and it wasn't. A big portion of it was not protected. So these are very important things that you need to make sure you go over before you file a Chapter 7 bankruptcy, or really any bankruptcy. But Chapter 7 in particular, because again, as I mentioned, you can file a Chapter 7, and if a trustee finds an asset like that, they will fight you tooth and nail, because the trustee gets a commission on any assets they find and can distribute to your creditors. So they have a vested interest in finding assets. It's their job. It's what they're supposed to do. So they're going to fight you tooth and nail for you not to be able to dismiss that case. So you need to, again, know what your assets are before you're going into a bankruptcy. Let me tell you another nice thing about Chapter 13. I have a lot of clients that have tax issues, and some tax issues are pretty hairy. They don't even know if they actually filed their returns. They don't know, when they received their assessments. It's a hot mess. And so they want to file a 7 to get rid of taxes, but they know there's going to be some taxes that they're still going to have to pay. And so a couple of things. Number one, most folks don't want to pay additional attorney fees to have a special motion filed in their bankruptcy to have it determined what those taxes are, because that's additional work, it's an additional hearing, and it will take a minute to do. So yes, you can do that in a 7, but it's going to be additional funds. And the other issue you're going to run into in a 7 is, okay, yes, there's probably a good chunk of the taxes that will be discharged, but then what are you going to do with the rest of them? And so Chapter 13 is a great vehicle for doing that. So a lot of times you can file a Chapter 13, you get the same benefit of the 7, meaning you get rid of all of your unsecured debt. You're not paying anybody back that you wouldn't have had to pay back in the 7. So that's great. We call it a 0% plan. Most bankruptcies are actually 0% plans. But you get the benefit of keeping control of the situation, and it will allow you to set up your own repayment plan with the IRS, with Georgia. Or if you owe child support, you could do it with child support, or alimony, you could do it with alimony. It gives you up to 5 years to set up your own repayment plan, and that's a powerful tool. The other thing I know a lot of my clients like to do, especially the ones with really messy tax issues, is in the 13, the IRS or Georgia, or whatever taxing authority we're talking about, they're going to have to file a proof of claim. And the proof of claim has to list what year you owe for, if it's priority, if it's secured, if it's unsecured, when it was assessed. So it's great because in a 13, you're going to pretty quickly know exactly what the claims that are being asserted against you are. Whereas in a regular 7, you file, the IRS or whatever taxing authority, they're not going to file a proof of claim in your Chapter 7 case. You're going to do your 7, you're going to come out, and then, we tell our clients, wait probably about 6 weeks when you come out of your 7, and then reach back out to the taxing authority to get an updated tax report so you can see what discharged and what didn't. But in a 13, you're going to know that quickly. So that is a big benefit of Chapter 13 over Chapter 7, is it gives you more control of the situation, and especially when you know you're still going to have residual debt that you're going to have to pay, and maybe that could be a challenge. A 13 is going to just give you control to not only get rid of all that unsecured debt, it lets you deal with the debt that you wouldn't be able to get rid of anyway, and it's on your terms. Another thing I want to talk about in regards to Chapter 13 versus Chapter 7, a lot of people don't realize that bankruptcy is flexible. And I mean super flexible. So you can be in an 11 and go to a 7. You can be in a 7 and go to an 11. You can be in Chapter 13 bankruptcy. You can be in a Chapter 13 bankruptcy for 6 months, a year, 3 years, and if something happens where all of a sudden, you're gonna have to either let assets go, or maybe your income has decreased that you now can qualify for a 7. You can just flip. You can just switch over. It's that easy. Now you can switch from a 7 to a 13, but it takes a court hearing. It has to be done usually pretty quickly after the 7, and cannot be so smooth, but you can do it. But the nice thing is you can start in a 13, see, especially if you have tax debts or you're waiting to see how some other claims are coming in, you can file the 13, you can do a restructuring plan with that debt that you're going to have left over. But if at any point you decide, what, I'm just going to convert to 7, and I guess I'll just deal with that, creditor down the road, like the IRS or Georgia or alimony or child support. If that happens, then you can just file a motion and convert. So that's another really great benefit of Chapter 13. And again, I already talked about you have the ability to dismiss your case. So in a 13, you have the absolute right to dismiss it. In Chapter 7, you don't. Also, this is going to start coming up a lot, and I know a lot of practitioners that just are oblivious to this. COVID, business loans, SBA loans. A lot of bankruptcy practitioners don't realize that when you are looking at debt and being able to go back and recover assets, because it's actually going to be based on the type of debt. So for example, there was a case where the gentleman had an SBA loan. this SBA loan, he defaulted on it. His business didn't work, but he had also done a property transfer. And property transfers, that's where trustees are really going to go after folks in Chapter 7s, because that's where they can get some big money, big commissions. So typically, a property transfer, the trustee here in Georgia can't go back any farther than 4 years. But if it is an SBA loan, there is a federal collection provision that they can use, and they can go back 6 years. So this gentleman had done a property transfer over 4 years ago, which would have been great, but because of the SBA loan, it extended it out to 6 years. And so now the trustee could go back 6 years, look at any transfers and try to challenge any of the transfers and try to claw, the property back into the estate. Now, with all this said, of course, trustees a lot of times will be very aggressive, honestly sometimes make ridiculous claims, and that's up to the caliber of your attorney to say, no, we'll just go to court, we'll fight it. And sometimes you have to do that, but you have to be aware, attorneys don't work for free. So if you get a Chapter 7 case and one of these little bombs is in it, yeah, you can fight the trustee, and there's legal arguments that can be made to try to prevent them from taking assets, but that costs money, and it's going to cost big money because you're going to go to trial, okay? So, you're going to be looking at least $5,000 minimum for a retainer for an attorney to take an adversary just to start ramping it up for trial. Sometimes $20,000, sometimes $50,000. So, yeah, you can fight it, but the fee that you paid for your Chapter 7 case, just for the regular case, you're going to pay a lot more. And at the end of the day, if you've had some property transfers, things like that, you could lose out even bigger because maybe the trustee is successful. So you could pay $5,000, $10,000 to fight it. They still win, and they still get to take the asset. So these are really, really, really important things you need to be aware of when you're evaluating whether or not you want to file a Chapter 7 bankruptcy or a Chapter 13 bankruptcy. And hey, we file a ton of Chapter 7 bankruptcies, and for a lot of folks, Chapter 7 is the right choice. But don't be afraid of Chapter 13. I have folks, and they really should not file a 7. I mean, I can tell them they're going to try to sell your house. They're going to do this. They're going to do that. And they just have in their head that 13, oh, no. I don't want to pay back. Most of the time, even if they have an asset that maybe the value is a little bit too high, it's still a smaller repayment schedule than paying all your debts back. So I would really invite you, if you're contemplating bankruptcy, especially if you have assets, like if you have a home, investment account, things like that, or you've sold assets in the past, you really, really, really need to make sure that you're getting the best advice and all the pitfalls that could occur if you elect to do a 7 as opposed to a 13. And I will make a note before I close out this video. Right now, we're in November 2020. Right now, I can tell you that property values, at least for the time being, property values are up. And really, they're higher than what's even listed on Redfi or Zillow or HomeSnap. I mean, their trustees are able to get a lot more than what's even reflected online. So when you file a Chapter 7 bankruptcy, the trustee, yes, we have to put a valuation, what you are estimating it at, but the trustee doesn't have to take your value. They have their own realtors that are going to go out, they're going to look at your property, and they're going to make an assessment as to what they think they can get for the property. And that's it. I mean, if they can get that for the property, they can sell your property if it's over what your exemptions are to protect that property. So, I have a couple of folks, and they'll come in and they'll have their appraisal. Nope, I got it appraised. This is what it is. That's nice, but at the end of the day, that's not going to save you. Also, whatever your county, sometimes people bring in the county assessments. Those are never right. And the court's not going to accept that. And the trustee's not going to accept it. It's going to be based on what the trustee today can get for your property. So just know that going into a Chapter 7. So, yes, there's ways that you can avoid your property being sold, but you're still going to be paying debt back. Whereas in a Chapter 13 bankruptcy, it's a lot different. Yes, the trustee still cares about the value. You still have to prove what the value is, but the Chapter 13 trustee is not going to sell your house. And so that's very reassuring. So when people come to me, and they may be like right on the line where their equity is really over what they can protect, I tell them, here are your options, but if you want 100% guarantee that nobody's going to sell your house and you're over on equity, do a 13. Do a 13. And yes, I mean, most 13s can go from 36 months to 60 months. It just depends on a couple of factors. Watch our video in Chapter 13s and I'll go over those. But a lot of times it gives you peace of mind and you're still not going to end up, any worse than if you had done a 7 and then the trustee goes to sell your house and you're still going to have to make a deal with the trustee and pay the trustee to prevent them from selling your house. And it's really stressful, and you'll probably have more attorney fees. So with my parting comment is, don't be afraid of Chapter 13. Chapter 13 can be a wonderful, wonderful solution to your debt problems. And with that said, if you have any questions about Chapter 7, Chapter 13, maybe any specific issues, if you're here in Georgia, I'm always happy. We do free consultations. I'm always happy to answer questions about it. But make sure that you're informed because, again, Chapter 7 can have a lot of pitfalls for those folks that have some of the issues that I just talked about. So if you want a safe bet, a lot of times it's going to be Chapter 13.